Good morning. Your name, please.
Isel, Nell.
Thank Appeal State of Michigan versus Isel, Nell Jr. 23 FB 1317. Allegations that on April 10, 2023, Ypsilanti Township, Washtenaw County, State of Michigan, on Grove, at or near Bryn Mawr Lane, you did maliciously, forcibly or fraudulently lead, take, or carry away, or decoy or entice away a child under the age of 14 with the intent to detain or conceal such child from its parents, guardians, and or persons who have lawfully adopted the child and or the person having lawful charge of the child. A felony carrying a maximum penalty if convicted of a term of up to life incarceration. Do you understand that?
Yes, I do.
Okay. You have the following rights on a felony charge. You have the right to remain silent. And you say on the record can and would be used against you at trial. You have the right to be represented by an attorney at all stages of these proceedings. This does include before, during, after trial, and at any time you're being questioned by a police officer. If you are unable to afford an attorney, one will represent you at public expense. Do you understand these rights?
Yes.
The court has entered a not guilty plea. The people may address bond.
Ashley Lundy for the people, Your Honor. At this time, the people are requesting a cash bond. We are requesting that the court enter a $200,000 surety bond. The allegations in this case are extremely troubling and bothersome. The defendant is alleged to have pulled a 12-year-old child into a car. We have also included in our bond information form. There are prior allegations of the defendant sexually assaulting this child. The people are extremely concerned about any contact between these parties and are also requesting that no contact order apply whether or not the defendant is in or out of custody and be extended to the victim's family and make sure that there's no other contact happening here. Your Honor, as the court also noted, this is, just double check one thing, potentially a life offense. So there is the potential that the defendant may want to flee. There's a flight risk issue here as well with the possible incarceration for the rest of his life. And the people are very concerned about that, which is why we make such a high bond request. Happy to answer any other questions the court has. Thank you.
So you indicate there's indications of prior contact between the defendant and the alleged victim here. Did any of those result in charges, or those still be investigated, or what are the status of those right now?
At the time of this report, the time of charging, it's my understanding they would be investigated in Warren, so I'm not aware of the status of them.
Thank you. Public defender would like to address bond.
Yes, Your Honor. We are just going to be asking for a lower and more affordable cash bond here with the condition that Mr. Nellen has agreed to a home confinement tether. He does strongly deny the allegations in the complaint. He states that the alleged victim is his daughter's older half-sister. They currently do not have contact. He and their mother are not together anymore, and they do not live with him. The address I've provided on the court-appointed attorney form is his mother's address in Detroit. He had been staying at a VA shelter, but has indicated that that was just due to his preference and that he is free to stay with his mother at any time. So again, we're hoping that the home confinement tether at his mother's house would mitigate some of that perceived danger to the alleged victim in this case. And of course, he has agreed and fully understands no contact. So again, we're just asking for a lower cash bond with the condition that he'll do the GPS tether. I do believe that he has a friend of the court matter scheduled for Monday as well.
Thank you. Ms. Londa, you'd asked for no contact with the minor victim, which of course the court will not name on the record here today, but you also indicated family members. Do you have names for the adults, family members, so we can enter those names into lien with regard to no contact?
Yes.
Okay. Go ahead.
Thank you. The child's mother. Let me make sure I give you the correct name. There's quite a few names in this. I'm not prepared to comment on that right now, but I would ask that that be a protected address. I understand there's been there may have been a change in address, and if I have an updated address, I would be happy to supply that to the court to add a future no contact or no go to area. but at this time, that is the address that I have.
Okay. Now, and the court's gonna set the following conditions for release, and we'll get to the bond itself after we over the conditions and a few other things. But the conditions will be that you're not to use or possess alcohol. Okay. Should bond be? Yes, ma'am.
Would the court consider adding a no go to the schools, the school of the child as well, in addition to employment at home? Thank you.
Yep, certainly. Okay, the court will add that provision as well, also not to go to any school where the alleged minor victim is attending school. All right.
Question when you're done.
Go ahead. What's your question?
Now, these allegations are false. Okay, I haven't seen them since Jan.
Okay, we're not gonna,
Nell,
Oh.
your attorney's going to address, your attorney will address the veracity of the allegations. These are allegations of you, as you have indicated. You are presumed innocent until proven guilty. So you don't need to address that at this point in time. And I caution you from saying anything further about the events here because you don't want to inadvertently indicate and say anything that could be detrimental to your case moving forward. Okay. All right. All right. So I'm gonna ask your attorney actually now to address conditions for you. Counsel, anything on conditions?
no, Your Honor.
Okay. All righty. Should a bond be posted in this matter, that there will be a requirement after bond being posted of a home confinement GPS tether to assure protection of the alleged victims in this matter. The home confinement will be to an address as approved by the court prior to release from the jail. So it may or may not be the address provided here. That would have to be investigated prior to that being permitted. Next court dates will be August 31st, 9 a.m. For probable cause conference. Matters not resolved at that hearing will proceed to a preliminary examination. That is a hearing at which point in time the prosecutor must present sufficient evidence and or testimony that there is probable cause crime was committed and probable cause you did commit the crime. Should the judge presiding over that hearing determine that probable cause does exist, the matter will be bound over, meaning transferred to circuit court for trial. That is tentatively scheduled for September the 5th at 9 a.m., although that second court date often is shifted at once the first court date happens. Do you understand the purpose of that hearing? Mr. Nell, do you understand the purpose of the
Yes.
under exam? Thank you. Okay. All right. So court is going to impose a cash bond for public safety, but I do want to make sure that we have all the conditions in place that everybody's agreed to at this point. Ms. Lund, anything further for conditions?
No, Your Honor.
Okay. Ms. Plum, do you have anything further conditions?
No.
All righty. All right. Given the nature of the allegations, given that we have a minor child that does not have the ability to protect themselves necessarily with regard to the disparity in size, age, and all the other things that come into play between a child and adult, the court does have really large concerns with regard to public safety and the safety specifically of this victim. For those reasons, the court is going to impose a cash bond for public safety and to assure appearance of future court dates. The people have requested a $200,000 cash bond. The court will grant that request for $200,000 posted either in cash or corporate surety. Subject is placed on the record. Should bond be posted, a GPS home confinement tether will be required to an address approved by the court prior to release, and then of course subject to all the remaining conditions placed on the record. All right, Mr. Nell, you're all set for today. Stay safe. You can tell him you're done.
Let me see, maybe late, I'm assuming I can't deny bond for some reason. Hello, could you state your name for the record, please?
Charles House.
Do you have any address, Mr. House, where you can receive mail from the court? Maybe on Lathers in Ypsilanti?
Yeah, my sister's address.
Okay. Do you have a phone number or an email address that you can give me?
I don't have a phone number or email. My phone broke.
All right.
This is on YouTube.
Oh, we're on YouTube, everyone,
For this one.
just so as you know. Okay, this is State of Michigan versus Charles House 23F55179. I have received a petition requesting a court-appointed lawyer. I will sign that. Go ahead when you're ready, Mr. Bellinger.
Thank you, Your Honor. Assistant Public Defender Jay Bellinger appearing with and on behalf of Mr. House, who appears via Zoom from the jail. Your Honor, we would ask for a formal reading of the charges. We did not have the papers available to us at the time of the interview.
All right. The complaint in this matter states that on or about August 31st, 2023 at Depot Street near North 4th Avenue in the city of Ann Arbor, Washtenaw County, Michigan, defendant is accused in count 1 of committing the crime of assault with intent to do great bodily harm, less than murder or assault by strangulation upon Lakrita Thompson. That's a felony with a maximum of 10 years or $5,000. Count 2 is a charge of unarmed robbery, stealing money and or jewelry and or a cell phone using force or violence against Lakrita Thompson. That is a felony with a maximum of 15 years. And count 3 is a charge of domestic violence, making an assault or an assault and battery upon Lakrita Thompson, an individual with whom defendant has a dating relationship. This is charged as a third offense because of previous domestic violence conditions, which makes that a felony. The maximum penalty for felony domestic violence is 5 years and or 5,000.
Thank you, Your Honor. As to the charges, we would stand mute at this time and reserve for bond.
Go ahead, Ms. Hines.
Your Honor, I know that this happened last week when we were here on something else, but there's also a second case that he's been charged in. Is the court aware of that second case?
Nope. We'll look for that in a minute.
Okay. All right, well, just with regard to bond on this case, Your Honor, the people are asking for a $1 million surety bond. And that's based on not only the serious charges here. In this case, the defendant was just talking to the victim and out of nowhere began strangling her. But also based on these other charges that our office is aware of. One of them is
There's not another case. It hasn't been approved by a judicial officer.
I do understand that, but I wanted to also just explain to the court where this bond recommendation is coming from, because we got 3 cases in at the same time, and they, in our opinion, based on all of those charges or all of those cases coming in at the same time, that are home invasion related.
Okay, but this is really a difficult way to do this. So when are the other charges going to get to a judicial officer and be ready?
Your Honor, I can't answer that because I don't take those over. I know that one of them has been charged and the other one is still in warrant status.
Nothing is I don't know. I think you're using those words that I use to mean something else. There are no warrants for his arrest other than this one that we're handling right now. So what does warrant status mean in your office?
That there is a case sitting in a queue that has yet to have a determination whether that's going to be charged, furthered, or denied.
Okay, so there's one file like that, and then one file where your office has authorized charges, but for whatever reason, it hasn't been approved by a judicial officer yet.
Correct.
What is the jurisdiction on that one? The police department jurisdiction?
And I'm checking that one right now. I believe it's Ann Arbor, but I just want to double check before I give you the, yes, Ann Arbor PD.
Maybe Detective Marshall knows something about it.
It was charged today as a home invasion first degree.
From July 31st.
August 31st.
Oh, what?
Mr. House,
I'm sorry, that's today, like it was charged today.
Isn't that the,
Date of offense.
what's the date of offense on that one?
August 29th, 2023.
Mr. Bellinger, my preference, of course, would be to handle everything tomorrow.
I would tend to
Detective
agree.
Marshall, is your office going to have that ready for us to do it tomorrow?
We are. I received the one authorized chargeback she's referring to. I'm still waiting on the other, and then we're in the process of getting a parole detainer on him. He's on parole for home invasion.
I
I
can make,
prefer to do it all tomorrow,
Yeah.
especially because the prosecutor is seeking a $1 million bond, and it's going to be a lot easier to determine whether that's appropriate when everything is in front of me. Anybody have a strong objection to that? Let me explain it to Mr. House.
Thank
Mr.
you.
House, the conversation that we're having right now is about other charges that are ready to authorized by the court against you, but have not yet been authorized. So as soon as those new charges, those other charges are authorized by either me or someone in Ann Arbor, then you will need to be arraigned on those charges also, and you won't be able to leave the jail until everything is resolved and you have bonds on all of your cases. No matter what I were to do today, you would still have to be seen on those other files. My preference is that everything gets handled together. It is easier to coordinate bonds, testing, tethers, instructions, court dates, all of it, if we do everything on the same day. So I'm suggesting that that's what we're going to do. Your lawyer seems to agree that that's a good idea, as does the prosecutor's office. So I'm going to see you tomorrow on all of it.
Yeah,
Okay,
yes,
I will see you tomorrow, Mr. House. Detective
okay,
Marshall, I will, so you're all set, Mr. House. You can walk to the door and step out.
I'll talk to you again before tomorrow.
okay.
All right, Detective Marshall, I will be here in the morning. I don't know if you can get to. Must be.
The two that don't have the,
He's already, no, only one. State of Michigan versus Charles Lawrence House. This complaint alleges that on August 30th, 2023 at 914 Sybil Street in the city of Ann Arbor, Washtenaw County, Michigan, defendant is accused of committing the crime of home invasion in the second degree, entering or breaking and entering without permission or breaking and entering a dwelling at that location, and while there committing a larceny. This is a felony with a maximum of 15 years and or 3,000.
Thank you, Your Honor. As to the charge, we would stand mute, and we will reserve the bond.
Go ahead, Ms. Tanha.
Thank you, Your Honor. And Your Honor, I know there were some cases yesterday. I'm not sure exactly how far the court got, if you would like me to.
We didn't finish anything yesterday because we became aware that these, we only had one available yesterday. And we became aware that there were two more. And so I decided that what made sense was for us to arraign and set bond on all three files together. I also was informed today by Detective Marshall from the Ann Arbor Police Department that the parole detainer has been put into effect properly now. Yesterday it was pending, I think.
Thank you, Your Honor. And if I may add, Your Honor, this morning, as I was preparing for the arraignments this afternoon, I did find another case with a date of offense of August 7th at 413 Ballard Street. Is that something that's, and I charged it at the home invasion second. Has that come through to the court? I did
Nope.
inform Mr. Bellinger there was another one.
Okay.
Nope.
Okay. It would have been, yeah, it was charged pretty last minute, as I just discovered it this morning. So if the court would like to proceed, of course we
I
can, but
would, because I think we have an, yeah, I think we should go ahead. I don't want to keep putting this off. And now we're at the weekend and then it gets hard. So let's just go ahead and handle these three. And when the other one is ready, then we'll see him on that. As long as we get that arraigned before Thursday, the 7th,
14th.
then they'll all be together on the 14th anyway.
okay, thank you. And it has been authorized, Your Honor, from our office. So it's done on our end at least, and should come through hopefully.
Is it in Ann Arbor jurisdiction also?
No, it's an Ypsilanti. Oh, you know what?
So
Yeah,
that's what the difference is.
Yeah.
Yeah.
that makes sense.
Okay.
Okay, thank you. So I'm sorry, Your Honor, which case would you like me to start with?
I don't need you to go over the substance of any of them. If you, of course, can, if you'd like. I took the testimony on everything, so I think we're just really arguing the issues related to bond, flight risk, and danger to the community.
Thank you, Your Honor. And Your Honor, for the record, my understanding in the cases is, well, the highest request for bond so far has been $1 million. Is that correct?
Yes.
And then I
Yes.
believe there was a perhaps two $500,000 requests, surety. Is that accurate also?
I thought there were two 1 million and one 500, but either way.
Either way. So Your Honor, this is, these cases are, of course, a string of home invasions that had involved not only larcenies, but also assaultive behavior towards the residents of those homes. We also have further assaultive behavior, the form of strangulation, which is a domestic violence related case, unarmed robbery in that case, and domestic violence third. Mr. House unfortunately has quite the history of assaultive behavior and break-ins into homes and larcenies. So we feel, based on all of that, and the court being aware of the fact patterns, I'm not going to go into detail, but there's a lot of concern for the safety of the public and as well as a specific victim in the domestic violence case.
Thank you.
Thank
Go
you.
ahead, Mr. Ballinger.
Your Honor, we understand the prosecutor's recommendations. Obviously, there is that hold now. We know we need some sort of financial bond here on these cases. I don't know that $1 million is anything but excessive at this point, considering the hold. So I would just ask for something necessary, whatever's necessary to keep them in the custody of Washtenaw County, so that we can process these cases and move forward from here.
So something is strange with his criminal history. I don't know how to fix that, but
Okay.
the arrest segment for Ann Arbor Police Department report number 2337914 and 2337904, which are two of the files I have in front of me. The arrest segment has the charging by the prosecutor and the warrant request from July 31st. And these events allegedly occurred on August 31st and August 30th. So I'm not sure why that says arrest prior to the incident date, but just so everybody knows, whoever's job it is to fix that should.
I think that's MSP.
Well, someone has to tell MSP.
Yeah, I understand. I'll
And I
I'll put a
don't
note in our
know, it might be the Ann Arbor Police Department because they would report the arrest portion.
Okay.
I don't know.
I think
And that-
if both sides make notes to have it taken care of, I'm sure it will. Thank you
Yeah,
for bringing
I
that to our
just-
attention.
Only because,
Yeah.
as everybody knows, things need to be correct when we find them so that we're all speaking the same language and talking about the same thing. And I think that's part of what was confusing yesterday, as Ms. Hines kept talking about a July incident, but nobody could locate it. Okay. So,
Thank
Mr.
you.
House, a bond has two parts to it. One part is whether the defendant is a flight risk. The other part is whether the defendant is a danger to the community. You're charged with 3 home invasions plus some other crimes occurring during the home invasions. Each of the home invasions happening 1 day, 2 day, 3 days. So 3 days in a row, criminal behavior that led to felony charges. All of that happening while you're on parole for another matter. So given those alleged facts, there is both a flight risk and a danger to the community represented by your current behavior. Furthermore, the parole hold means that in order for you to stay in our jail and get the first bit of progress on these cases out of the way, you need to have a financial bond. And thirdly, there is a statute in the state of Michigan, Michigan Compiled Law 765.6A, which requires a financial component when a person has 2 or more felony convictions within the previous 5 years. So for all of those reasons, the bond on each of these files is $100,000. Cash or surety, no 10%. You're not to commit any crimes while you're on bond. And no contact with. Well, I guess I don't have a name for the other home invasion.
I think that was the
People, so-
issue. I think I might have those names that Ms. Hines gave yesterday.
Okay,
Give me
Is
just
that
one
something
second.
you're
I'm
on-
look-
is that something your office thinks we should order, Ms. Tanha, is no contact with those other people too?
Yes, Your Honor, we would like that. Thank you.
Okay. And a no-go to one. The probable cause conference for each case will be on September 14th at approximately 9 a.m. over Zoom. You have those names or not, Mr.
Hey.
Bellinger?
You know what, Your Honor, I misspoke. I apologize.
Okay, so if your office wants those names added, Ms. Tanha, I don't
Yes,
think
ma'am.
you have them either then, do you?
Your Honor, I could go through the reports and get them, but that would require.
I don't know that we need
Sometime.
to for today, but
Okay.
again, if it looks like he's going to be leaving the jail, I don't think he knows who these people are. I don't think that it's a relationship. Okay,
We talked about-
other than Ms. Thompson. I'm sorry, Mr. Bellinger, what was that?
I said he and I talked about a contact from the jail and using the phones, et cetera. So he's been made aware of the contact provisions.
And he doesn't know the people, the home
I don't believe
invasion victims. Okay, just Ms. Thompson. And we do have her name and I am ordering no contact. Oh, here's
Thank
one
you.
of the names. Anna Wynn is one of the
Yeah,
names.
yeah.
Okay.
Yep, that's great.
All right, I think we're all set. Anything else that we need to do on this file? These files?
I don't believe so, Your Honor.
Thank you, Your Honor.
Okay. Mr. House, are you all set?
Yes, ma'am.
Okay, thank you.
Mr.
you, Your Honor.
Mr. Banger, will I be hearing from you?
Yeah, you'll be hearing from someone from my office, if not me, okay?
Okay. Also, you're not gonna be handling my case?
I'll be handling your arraignments, but someone from my office will be in touch with you, all right?
Yeah. Yeah.
Okay.
Okay, you're
I'll
all
give them all
set.
the,
Excuse me?
Okay, thank you. We can go off of YouTube too.
I probably won't feed me in jail.
Nicole, are you needing to check him in or you may just go ahead?
Yes, sir, I will.
You take my shit from the Salvation Army, but they probably lost every fucking thing I own.
Good morning, Mr. Thomas. I need to check you in for court this morning. Can I get a good mailing address for you, please?
1209 South Farley, Pampa, Texas. 7965.
You said 1205 South Farley, Farley?
Plain South Farley, Pampa, Texas 79065.
And a good phone number?
I don't have any phone number. He does. My dad's phone number was stolen out of my wallet. I can't report a crime in this town. I can't report stuff stolen in this town.
Just answer the question.
I can't do a goddamn thing in this town but get picked up by somebody and then every fucking thing I got got stolen.
Okay, Mr. Thomas, do you know your father's phone number or you don't?
I had it in my wallet when they fucking stole it.
Watch your language.
What's a good email address? Do you have one?
I used to a while back.
Okay.
I don't remember it.
Okay, all right, thank you, sir. The judge will be with you shortly. Okay.
Hey, Mr. Thomas, I'm Judge Henderson here at the court. I'm just going to talk to you real quick about your case. Let me tell you what your options are, and then you can decide what you want to do, okay? You can plead not, you have the public intoxication. That was from the 21st. You can plead not guilty if you want to have a trial. You can also plead guilty or no contest. I would set the fine at $210. Court costs would be $81, and that because you've been in jail for several days, you would be time served on that, so you wouldn't actually owe any money and you would be done on this. What do you want to do, sir?
I'm gonna plead not guilty.
Okay.
I'm gonna say I'm not guilty.
Hold
But it
on.
doesn't
Wait a
good.
second. Stop talking for a second. I don't need a whole story. I just need to know if you, here's the thing. If you want to plead not guilty, I'll set a bond, but you'll need to be here on Monday at 2 p.m. at the municipal court. If you plead, stop talking. If you plead guilty or no contest, I'll time serve you and you'll be done with this case and you won't have to be anywhere. I'm okay, whatever you want to do. I just want to make sure you understand that if you plead not guilty, we need to see you on Monday. And if you're not here, another warrant is going to issue.
Okay.
Which one do you want to do? Do you want to plead not guilty and we'll see you on Monday? Do you want to plead guilty or no contest and your time served? Which one of those do you want to do?
No contest.
Okay.
If I'm time served on no contest too, right?
Yes, you are time served. I've accepted your plea of no contest, found you guilty. Your time served. So you're all done. It looks like this is the only thing. It looks like this is the only, stop talking. It looks like this is the only thing holding you. So you should be released. Okay.
The only reason I picked up that bottle of lost turkey was because it was in a parking lot. I didn't want somebody to run over it, sir.
Well, that's some civic duty that you performed, Mr. Thomas. I know the drivers appreciate it.
And we still don't have anybody connecting? All right, nobody's trying to connect or in the waiting room. All right, solicitation of a minor scores a, who was a student in his class, it appears, scores a 4. What does the state feel is appropriate?
Yeah, court's brief indulgence.
Sure. And while you're doing that, I want to talk to the defendant about, he indicated he was going to hire his own attorney. What's going on with that, Mr. Coker?
I was not able to make a phone call yesterday, and I don't have any money on my account to be able to contact anyone to get an attorney.
All right. What is your ability to hire an attorney? I see that your income was $1,500. That was from the school district?
Yes.
And I assume you're not going to be getting that probably. What
And I
your
also-
assets are, Your assets are a $9,000 credit card or that savings account. What is that?
Savings account, and then I have my own business where I haul heavy equipment in the Reno area outside of teaching to make up for the lack of pay for teaching.
Okay, so you have $9,000 in cash to put down with an attorney, and then you feel you can make payments. Possibly. Okay, so you today don't have the ability to hire an attorney, right? You
No.
said.
No, I haven't been able to get. a
All
hold of
right, do you
anybody.
want the public defender's office today to assist you in this hearing?
That would be nice, yes,
Is that a yes?
yes,
All right, now you understand you're gonna have to continue to try and hire counsel, and every time you come to court, the judge is gonna ask you what, just like I did today, what have you done to try and hire an attorney?
yes,
All right, and if at some point you talk to 3 attorneys and none of them will take your $9,000 to represent you, they all want more, then you be entitled to the public defender, but you at least need to try. Do you understand?
yes.
All right. We'll allow the public defender to be appointed in this case, subject to future review for indigency. Are you ready, Mr. Zakari?
Yes, Your Honor, thank you.
All right,
State's
go ahead.
requesting bail in the amount of $1 million, no contact with the named victim or any juvenile under the age of 18 years, GPS house arrest if he's able to post, and no weapons or firearms as well if he's able to post. Certain things to highlight with the allegations here. I'm assuming Your Honor is familiar with the facts and circumstances in that PC sheet. Just highlight a few, and I think they're probably apparent to the court as well. Obviously, the defendant's occupancy, or not occupancy, the defendant's job as a teacher in this case, obviously very concerning the state, giving him access to the victim in this case. Defendant admits to what occurred in those text messages, essentially offering money for sexual favors from the underage student at his school, at Hug High School. There's also some other things that are egregious in that PC sheet, including law enforcement finding other text messages with other students in the defendant's cell phone, as well as the statement in one of those text messages involving another student at the school. I believe the statement was coming to his desk and giving him massages or rubbing his leg. So the state fears that the named victim in this case is not the only one, the only victim at the hands of Mr. Coker in his position of authority as a teacher at Hug High School. We were able to make contact with the parents as well as the named victim in this case. We were anticipating the potential appearance of these parents, but this has been continued one day and we were able to make contact with them. They are very concerned generally for their son's safety. They don't know much information about the relationship between the defendant and their son, but they are concerned if the defendant were to be released, as well as what this effect is going to have on their son as well, just the allegations in general. As far as our actual contact with the named victim, they did indicate that they are afraid for their safety if the defendant were to be released. Specifically mentions because this victim was the one that came up and spoke about what had occurred. And so he specifically mentioned having safety concerns for that reason. And I think that's fair for the victim to feel that way. I understand he scores a 4 on the NPRA, and I don't see any other criminal history, but everything that the state has just highlighted that was found in that PC sheet, I think shows and demonstrates the potential for ongoing criminal activity and just the severity of this and the risk to the community if the defendant were to be released, as well as a flight risk. Again, I believe the defendant did admit to law enforcement to his actions that were detailed in those text messages. So for all those reasons, the allegations of the PC sheet and the parents' concerns, as well as the victim's concerns, State believes that $1 million with house arrest, no contact with the victim or any juvenile under the age of 18 would be appropriate. Thank you.
All right, thank you, Ms. Cook.
Thank you, Your Honor. As you heard, with Mr. Coker and the issue with attempting to retain an attorney that he would not be able to afford the $1 million that's being requested by the state at this time. We were able to further confirm, as the state presumes, that although his employment with the school district is probably not going to be an option for him moving forward, he does have another business that, as you heard also from Mr. Coker, that he utilizes to have additional income, and that business we were able to confirm with his reference. We were also able to confirm his telephone number. Obviously, law enforcement was able to do that as well throughout their investigation. He does have a home where he has resided for the past 3 years. He has been employed, as the probable cause sheet indicates, for a long-standing time with the school district. So he is employable, has had the ability to maintain residence as well as employment with his own business as well as the school district. He is a low risk on the risk assessment. I think at this point would only be scoring for his age at first arrest, which this does represent. In terms of the allegations that are concerned, what I would note is that Mr. Coker was compliant in the investigation. He went down to the school district to turn in his computer and to deal with whatever the school district and law enforcement might have been investigating in regards to this case, which is where he was arrested and spoken to by law enforcement. He for sure could have fled or not appeared at that appointment if he, given the kind of allegations that he was facing and obviously being in trouble at work and perhaps not knowing the full extent of what he was facing, but he did have the opportunity to flee and not comply with that request to meet with them down at the school district offices, but he did meet with them. Again, he has been in the community for quite some time. He has no issue with a no contact order. Obviously, that is appropriate given the nature of these allegations. He would comply with that, no problem. I think his lack of history shows that he is not in general a risk of reoffending. I know that there are supposed, perhaps maybe additional conversations that law enforcement alluded to in the probable cause sheet. But at this point, all that law enforcement could say is that they believe that they are conversations with other students, no indication or facts or, no ad book charges, at least up at this point, as far as anything else that was untoward in those conversations or being able to link them to any other students. So what we would ask is that bail be set lower in Mr. Coker's case. I understand, given the nature of these charges, that the court is inclined to set some monetary bail, but I don't think that $1 million is warranted in his case, based off of some alleged text message conversations, given his lack of history and his significant ties to the community.
All right, thank you. Again, this is a case that's very difficult for the court to set conditions to ensure the safety of the community and the appearance of the defendant. We have had cases where individuals have been ordered to not possess any phones or computers. The federal marshals have gone in and installed software on the routers to make sure that there's no access, and those individuals or we've had individuals circumvent those measures and still solicit minors. It's an incredibly difficult charge to minimize the risk individuals pose. And I have released a defendant on a sexual assault case on unknown recognizance release. I've released a murder defendant before. It's not that the charge automatically dictates bail. That's not what the law is. Can I set those conditions? And in both those cases, I felt confident that I could. And in both those cases, I ended up being right, as far as we know. But in this case, given all the facts and circumstances, I do believe the state has shown by clear and convincing evidence that bail outside the defendant's ability to make it is necessary to ensure the safety of the community and the appearance of the defendant, that a forward will be set as requested. $1 million, no contact with this victim or any other minor. I am going to ask that we enter this into NCIC as one of the new no contact orders that'll be in the database for law enforcement. He shall wear a ankle bracelet before release, residential confinement in place before release. Checking with DS's order of bail laws, make all court appearances. September 29th at 9 a.m. is the next court date for the filing of criminal complaint. We'll see you back then. Thank you.
In your honor, just to follow up on that, if I may, as far as that condition of putting it in the NCIC, my understanding is one of the conditions is the defendant needs to be informed that he could be prosecuted as a misdemeanor charge if he were to.
Yeah, it's in the judicial release order
Thank you.
that every defendant has to sign.
Thank you.
Yep. All right. Thank you, everybody. So just ask Monday what you do about that.